1 minute, sir. Served, is it?
Served.
Complainant is served.
Not appeared. Let me give your lordship a bird's eye view of the facts of the case.
Synopsis hakil boyara. What with which? Why? Synopsis and list of authorities.
Good.
Yes, sir. Tavu heli, sir.
Madam, the petitioner before your lordship is a well-known, popular, and recognized professor of the Indian Institute of
Indian Institute of Science.
Indian Institute of Science with multiple doctorates and all that. And quite recently, he was deputed to a foreign country for as a delegate on behalf of the government of India. Quite recently, just about 10 days back. No, but all those things may not weigh much in your lordship's judicial. I'm just inviting my lord's kind attention only to show to your lordship the character, the conduct that would be imagined of this person. Except in that, nothing else. But on 30th of September 2018, there was a birthday party in the house of petitioner. Birthday of his daughter. But many were invitees to that birthday function. But the case of the prosecution in a nutshell is, on that day, the petitioner would go behind the screen, window screen, stand there. But while the children were playing some game, one after the other would keep moving near that window. And this man would keep touching inappropriately all these young girls, children. That is the case in a nutshell. I can understand one, I can understand two, I can understand three. Not one and all who had come there, unless and until, my lord, he is a maniac. He is a maniac. Well, that in a nutshell is the case of the prosecution. Well, basically, I am on certain important, serious legal issues which I have raised for my lord's kind consideration. Well, Lord, may I just first request your lordship to kindly turn to ink page 38. The proceeding sheet of the case, it commences at page 37. Have a look at page
I have granted an interim order, right?
Yes, interim order is there.
38.
38.
Cognizance.
Cognizance. But Lord, peruse the police report.
Yes.
And documents submitted along with the said report. On being satisfied exercising power under section 191B and 193 of the CRPC, cognizance is taken for the offences punishable under section 7 and 8 of the POCSO. Well, the 7 is the definition of the sexual assault and 8 is the penal class. Office is directed to register the special CC register with due conversion into crime number. Office to attend regarding the compliance of section 35(1) of the POCSO Act, securing statement under section 164, medical report, FSL report, property form, etc. Well, it involves here this order two things.
Yes.
Number one, well, cognizance. This is certainly not in keeping with the mandate of law as mandated under section 190 of the CRPC.
Yes.
He does not even say that he has taken cognizance. It doesn't matter. Well, probably your lordship may say it implies when once he says that he has perused the records of the case, it may imply that he has taken cognizance. Well, peruse the police report and the documents. Kindly read para 3 of this order at page 38. Office to attend regarding compliance under section 35(1) of the POCSO Act, that is securing statement under section 164, medical report, FSL report, property form. Which document then he has perused?
Everything is pending?
Yes, my lord, not even produced. Secure these documents. What is it that the learned judge has perused then? For him to have taken cognizance, he has perused nothing.
Yes.
It is certainly not in keeping with the mandate of law as mandated under section 190 of the CRPC would be my first submission. Because he was not having the advantage of the statements of witnesses,
FSL report and other
Not
things.
even medical report, no FSL report, no properties, nothing, zero. Therefore, peruse the police report, my lord, does not certainly imply an application of mind on the part of the magistrate, which was required to apply at the stage of taking of cognizance. That would be my first submission. Well, the second submission would be under section 204 now. Well, under section 204, what the learned judge was required to see or find out is existence of sufficient grounds for the purpose of issuance of process to the accused. My lord, day in and day out, we are canvassing before your lordship. 204, my lord, is not only in relation to a private complaint, but also in relation to a police report. That is the only power which you could exercise for the purpose of securing the presence of the accused by issuing process, be it an ordinary summons or a quasi process or a proclamation, whatever it may be. So what is needed to be seen by the learned judge when he exercises his jurisdiction in 204 is existence of sufficient grounds for the purpose of issuance of process. Well, there is no order under section 204 at all. May I now request your lordship to kindly, again, my lord, page 38, after he takes cognizance,
Process not issued.
illa 204 ilve illa, non-compliance.
Basics they forget.
Blood. ಇದು 1000 ಸತಿ ಹೇಳಾಗಿದೆ, ಅವರು ಟ್ರೈನಿಂಗ್ ಕೊಡುತ್ತೆ, ಎಲ್ಲ ಮಾಡುತ್ತೆ. This is the latest judgment of the Supreme Court. Your lordship, is in the case of Vikas Chandra.
Yes.
Following
Taking of cognizance is not
yes, my lord, they are
a
totally
casual thing.
yes. My lord, may I just request your lordship to kindly attend to this is the latest judgment, my lord.
Yes, yes.
Paras 13 and 14, if my lord permits me, I shall take your lordship on the small paragraphs. A close scrutiny of the position of law. Well, I'm not satisfied with, my lord, if my lord is persuaded to accept my submissions, ultimately your lordship may say, why on account of the mistake or the fault on the part of the court, the party who is aggrieved should be made to suffer. Your lordship may even say, all right, we will set aside this order and remit the matter. No, I'm not happy with that. Anyway, I'm just inviting my lord's kind attention to several legal issues which have raised for my lord's kind consideration. Kindly go to paragraph 13 of the judgment in Vikas Chandra's case. This is in 2024, April part. A close scrutiny, my lord gets it?
February 22nd.
Yes. 22nd.
Written on February 22nd.
How?
Yes, sir.
Yes, February 22nd, but reported in Supreme today, April 2024.
ಇದು unreported ಕೊಟ್ಟರು.
ಅವ್ರು ಕೊಟ್ಟರು ನನ್ನ ಹತ್ರ ಎಸ್ ಇದೆ ಸುಪ್ರೀಂ ಟುಡೇನೇ ಇದು ನನ್ನ ಹತ್ರ ಬುಕ್ಕೇ ಇದೆ ನನ್ನ ಹತ್ರ. It is reported, madam.
2nd February ಅಲ್ವಾ?
Yes. A close scrutiny of the position of law revealed from the aforesaid decisions, which are constantly and consistently being followed by this court, would reveal that issuance of summons in a serious matter is a serious matter, and therefore shall not be done mechanically, and it shall be done only upon satisfaction on the ground for proceeding further in the matter against a person concerned based on the materials collected during the inquiry. Well, here my submissions are two-folded. Number one, there is no order as such passed by the court under section 204 at all. Probably, in that view of the matter, this judgment did not be referred to or adverted to for this reason, that there is no order at all. Proceeding with an assumption for the sake of argument, they are not considering for a moment that there is an order. For that, my lord, right from any number of judgments, in the aforesaid circumstances, the next question to be considered is whether a summons issued by the magistrate can be interfered with in exercise of the power under section 482 of the CRPC. In the decisions in Bhushan Kumar and another was the state of NCT, and in crime number so-and-so, Pepsi Food, their lordships would refer to more than one judgment, and then thereafter their lordships, whether the learned magistrate applied his mind to form an opinion as to the existence of sufficient ground for proceeding further, and in that regard, to issue summons to face the trial for the offense concerned. In this context, we think it appropriate to state that one should understand that taking cognizance empowered under section 190 CRPC and issuing process empowered under section 204 CRPC are different and distinct. Well, probably there is one.
Following Sunil Bharti Mitra.
Following, that is a larger bench judgment, a full bench
bench.
judgment, their lordships would follow. Well, in paragraph.
In 4 SCC 609,
Paragraph-
48, 49 of
Yes,
it.
paragraph
48 and
48,
49.
49. At least, though not in detail, at least in one or two sentences, he has got to say, indicate that he has perused and there exists sufficient ground for the purpose of issuance of process against the accused. But
And
at this-
GHCL 13.
with 30
Yes.
Pretty difficult. ಅಲ್ಲ, ಸಾಹೇಬ್ರ ಹತ್ರ ಗೊತ್ತು ಬಿಡಿ ಅದೆಲ್ಲ.
GHCL.
ಅಲ್ಲ ಅದು ಕೊಡ್ತೀನಿ ಅಂದ್ರು
It's 13 4 SCC 50.
day in and day out, my lord. These are the points which we would be canvassing before your lordship. Therefore, there has been not only non-compliance with the provisions of section 190, there is non-compliance with the provisions of section 204 also.
No, 204, if there was an order, we could
There
have
was
examined
no
whether,
order at all.
no, if there was an order, we could have examined whether there was application of mind
Whether there
sufficient
is-
material.
Whether he has
When there is
recorded-
no order,
when there is no order at all. Well, kindly see, let me not. Next day's order, Miller, 21 December 1978,
page
same page,
38.
38. Accused is present. Correct? Without
Accused-
even summons.
Accused is present.
Yes,
Summons ಯಾವಾಗ issue ಮಾಡಿದ್ರು?
summons issue ಆಗಿಲ್ಲ.
21 12 18.
ಇದು ಹೋಗ್ತಾರೆ ಪೊಲೀಸರು ನಾಳೆ ಕೇಸ್ ಇದೆ ಬಾಯಿಲಿ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಕರ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಪ್ರೊಫೆಸರ್ನ ನಿಲ್ಲಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿ. ಅಷ್ಟೇ ಆಗಿರೋದು. ಇದೇನು ಪ್ರೊಫೆಸರ್ ಅಂದ್ರೆ ಸ್ವಲ್ಪ ಹೆದರ್ಕೋತಾರಲ್ಲ, ಕೋರ್ಟು ಸರಿ ಕಾನೂನಿನ ಹೆದರ್ಕೋತಾರೆ, ನರ್ವಸ್. ನೆಕ್ಸ್ಟ್ ನೋಡಿ ಸ್ವಾಮಿ, ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಎ ಲುಕ್ ಅಟ್ ದಿಸ್. Accused is present for hearing before charge. Next day charge framed.
Next day charge framed.
Yes, my lord, 3112. Have a
H.
look at 3112.
Page.
Page 39.
Accused is present. Counsel for the accused so and so. Post for framing of charge. Accused
Page-
is present.
Page 68 is the typed copy.
Typed copy ಇದೆಯಾ?
ಇದೆ ಹಾಕಿದೆ.
ಇವರು ಬರೆಯೋದು ಡಾಕ್ಟರ್ಸ್ ಗಿಂತ ಕಷ್ಟ.
ಹೌದು ಹೌದು.
ಡಾಕ್ಟರ್ಸ್ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಇಸ್ ಇಂಪಾಸಿಬಲ್ ಟು ಡಿಸೈಫರ್. ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ಸ್ ಹಂಗೆ ಆಗಿದೆ. ಎಸ್. ಪೇಜ್
Page 68, madam.
68.
68.
What date is that?
That
Counsel
one,
for the accused present, charge sheet copy furnished under section 207. Accused is present, counsel is submission present upon submission, posted for charge. Charge is read out, explained to him, not guilty.
Lordship may recall to your lordship's memory. In one of the cases which my lord has passed an order saying that where my learned friend has also appeared in that case, that Murugamat's
Oh, ಅಲ್ಲೇ.
case. Supreme Court has confirmed that order.
Confirm.
Yes.
Challenge ಮಾಡಿದ್ರಾ?
Yes, my lord. Supreme Court has confirmed in the sense in a subsequent order which came to be passed by the Supreme Court, where the appointment of an administrator.
So
came
that
to-
was challenge.
That was challenged. In that, their lordships would make a reference. The High Court has already directed the alteration of charges on more than one ground. The trial court shall proceed to frame the charges
Oh,
as directed by the High Court,
By my order.
by your lordship's order. In that judgment, why I am inviting your lordship's attention to that judgment is for this reason. Under section 227 and 228 of the CRPC, well, merely because I give a concession, I am not giving any concession to the court.
So
Ultimately,
that is a duty cast upon the
Yes.
court.
well, that is what the
That's
Supreme-
what I've written.
a full bench judgment of the Supreme Court in Sanjay's
So
case.
the interplay between 227 and 228 was completely ignored.
That's how your lordship has.
So in that what's the PG scam matter also I've written one.
Yes. Well,
ಅದ್ರಲ್ಲೂ ತಾವೇ
well,
appear
a duty is cast upon the court to examine the record of the case. My concession to the court.
Because 228 springs in only after 227 is satisfied.
So he is satisfied. Here, my lord, I have not given any concession to the court here. The court proceeds to frame a charge against me.
ಯಾವ ಪ್ರೊಫೆಸರ್ ನ ಕರ್ಕೊಂಡು ಹೋಗಿ ಎದುರಿಸ್ಬಿಟ್ಟು ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡಿದ್ರಲ್ಲ. ವಾಟ್ ಇಸ್ ದಿಸ್?
ಇನ್ನೂ ಹೇಳ್ತೀನಿ ಅಲ್ಲ, ಇಷ್ಟೇ ಸಾಲಲ್ಲ, ಇನ್ನೂ ಇದೆ, ಬೇಕಾದಷ್ಟಿದೆ. ಒಂದು ನಿಮಿಷ ತಡಿ.
ಇಲ್ಲ, ಕೋರ್ಟ್ has terrified this man. He said
ಅಷ್ಟೇ.
whatever he says charge frame ಆಯ್ತು frame.
ನಿಲ್ಲಿಸ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಹೇಳುತ್ತದೆ.
Represented by counsel.
What counts? What procedure?
ಕೌನ್ಸಿಲ್ ಇನ್ನೇನ್ ಮಾಡ್ತಾರೆ, ಹಿಡ್ಕೊಂಡ್ ಬಂದ್ರೆ ಕೌನ್ಸಿಲ್ ಇಲ್ಲದೆ ಇದ್ರೆ ಜೈಲ್ಗೆ ಕಳಿಸ್ಬಿಡ್ತಾರಲ್ಲ. ಕೌನ್ಸಿಲ್
ಯಾಕಂದ್ರೆ you have
ಜೈಲಿಗೆ ಕಳಿಸ್ಬಿಡ್ತೀರಿ.
the dragon in front of you, POCSO. Yes. Yes, sir.
Well, now, may I just request your lordship to kindly go to the statements of witnesses which the investigator has recorded during the course of investigation of the crime.
It's part of the record here.
Yes, my lord, I have produced. We need to put an end to this
Yes,
kind of
this
practice.
is why I'm hearing. Otherwise, I would have passed an order straight away because there are judgments which cover the entire issue. This should be stopped.
ಅಲ್ಲ ಇದು ಮೆಕ್ಯಾನಿಕಲ್ ಆಗಿ ಒಬ್ಬ ಸ್ಟೇಷನ್ ರೈಟ್ ಏನ್ ಮಾಡ್ತಾನೆ, ನಾನು ಮೇಲ್ಕಂಡ ವಿಲಾಸದಲ್ಲಿ ವಾಸ ಅಲ್ಲಿಂದ ಶುರು ಆಗ್ಬಿಡುತ್ತೆ ಅವಾಗ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಇನ್ ಒನ್ ಆಫ್ ದಿ ಕೇಸಸ್ ವಿಚ್ ಐ ಹ್ಯಾಡ್ ಆರ್ಗ್ಯೂಡ್ ಅಬೌಟ್ 45 years back, my lord, before a bench of Justice Hanaya and Justice Nesargi,
Yes, sir.
they had said, my lord, it is a case of bride burning. It was third degree burns. Kerosene came to be poured on the head of that lady. Whole body was burnt. My lord, the only thing she could do is, when the policeman or someone else goes, ಅರೆ ಉರಿ ಕಾಪಾಡಿ ಅಂತ ಹೇಳ್ತಾರೆ ವಿನ, ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿದ್ದೇನೆ, ನನಗೆ 4 ಎಮ್ಮೆಗಳಿದೆ, 4 ಎಮ್ಮೆಗಳಲ್ಲಿ ಇಷ್ಟು ಹಾಲನ್ನು. Would she be in a position to make such a kind of statement at a point of time, my lord, when she was about to breathe her last? A dying declaration which runs to about 2 to 2.5 pages with third degree burns from top to bottom. This is what they do. Well, may I just...
No, that is known. You think the charge sheet, the summary of the charge sheet is written by the investigating officer? Illa. Alli police station writer bariyadu. Every 498A case has verbatim similar things written by the writer in the police station.
In fact,
No IO writes it.
In fact, this court, my lord, in the unreported judgment, speaking through Honorable Mr. Justice Venugopal Gowda, has written an order, but that is not a reported judgment. Ultimately, what his lordship would say is the trial court, before proceeding to frame charge, shall consider all these things. This court did not lay down any law. May I request your lordship to kindly have a cursory look at section 160 and then 161.
Here.
Kindly go to 160 first before I take your lordship to 161. Then I shall take your lordship to the statements.
No, because we'll elaborately consider this.
Yes.
Yes. 160.
160. Police officers' power to require attendance of witnesses. Well, that he can certainly secure when he exercises power under section 160. That is the power of policeman as far as investigation is concerned, which he does under 154. Well, now kindly go to 161 now. Any police officer making an investigation into this chapter,
Yes.
or any police officer not below such rank as the state government may by general or special order prescribe in his behalf, acting on the requisition of such officer, may examine orally any person supposed to be acquainted with the facts and circumstances of the case. He can certainly do it. Now let us go to 2. Such person shall be bound to answer truly all questions relating to such case put to him by such officer, other than the questions, the answers to which would have a tendency to expose him to criminal charge or to a penalty or forfeiture. Well, the consequent to the protection that is given to him under the Constitution. Number 3, this would be important. The police officer may reduce into writing any statement made to him in the course of an examination under this section, and if he does so, he shall make a separate and true record of the statement of each such person whose statement he records. That question he has to put. That is under 161(1). Then, my lord, he must truly record it. Now, my lord, let us see how he has recorded. May I just request your lordship to kindly turn to page 13 of the charge sheet which I have filed on 17th of March 2022.
Well, happy. Charge sheet.
Along with my memo, I placed it entire 17th.
ಅಲ್ಲ, ಅಟ್ಲೀಸ್ಟ್ ಒಂದೊಂದು ಅಕ್ಷರನಾದ್ರೂ ವ್ಯತ್ಯಾಸ ಬೇಡ. ಒಂದ್ ಸ್ವಲ್ಪ ಎಲ್ಲರೂ ಅದೇ ತರ ಹೇಳ್ತಾರ ಮಕ್ಕಳು ಪ್ರತಿಯೊಬ್ಬರು. ನಾನು ಮೇಲ್ಕಂಡು ಅಲ್ಲಿಂದ ಶುರು ಆಗ್ಬಿಡುತ್ತೆ. Doesn't matter. My lord, may I just request your lordship to kindly turn to page 13.
ಮಾತ್ರ ಇಲ್ವಾ?
13.
Charge sheet copy ಇಲ್ವಾ ನಿಮ್ಮ ಹತ್ರ? What is this?
I'll give it.
ಕೊಡಿ.
ನಮ್ಮ ಹತ್ರ ಇದೆ. ಕೊಡಿ. ಜಗದೀಶ್
ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಹತ್ರ ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ಇಲ್ಲ.
ಅವ್ರಿಗೆ ಯಾತಕ್ಕೆ ಅಂದ್ರೆ ಪ್ರಾಬಲಿ he would have conceded ಅದಕ್ಕೋಸ್ಕರ ಇಟ್ಕೊಂಡಿಲ್ಲ.